welcome. Now let me move on. See, the first thing I want us to discuss this morning, bring to attention, yesterday the Chief Justice dealt with this matter involving SOKU. And, as teachers, we are not going to assume that everyone on this live is aware of actually what transpired. But so I'm going to walk you through very, very quickly what transpired. Back in October last year, the 28th, I think it was the exact date, an attorney at law, Tamika Clark, was arrested by ranks of SOKU, Ramana, Duke, Singh. They arrested her because she advised her client not to sign a statement that they claim that SOKU had provided. They arrested her, and I'm going to read exactly what the thing says. So the Chief Justice had made some preliminary ruling, I think, in July, and then the final ruling was entered on the 20th. That is Monday. And here what it says. They go on to say, let me tell you first what happened. Let me tell you what was reported by Ms. Clark. She said Clark had testified before the court that she had been practicing law for over 7 years and had been retained by Leon Lespar on October the 25th and accompanied him to SOKU in relation to an ongoing investigation related to him. She said that while there, they met Constable 23975 Shakil Juk and was joined by Superintendent Ramana, who indicated to her that he required Lespar to provide a statement concerning an ongoing investigation and inquired about her client's availability to provide the statement. She said that they agreed to return on October the 27th as requested, but also informed him that our client will be exercising his constitutional right to remain silent. Superintendent Ramana asked me if I was aware of what obstruction meant, and he indicated to me that Lespar was compellable to provide a statement. Superintendent Ramana further indicated to me that if I prevented Mr. Lespar from providing a statement, he would arrest me, and that counsel may need counsel on the said date. On October the 27th, Clark, along with our firm's senior partner, Sean Alika, accompanied our client to SOKU, where they were informed by Sergeant Winston Singh, that Superintendent Ramana was busy, and were advised to return the following day. The same team returned on October the 28th, where a number of events played out. At the said location, I was informed by Mr. Lespar and verily believe that the police provided him with a written statement and requested for him to sign it. I repeated my advice to Mr. Lespar about his right to remain silent, and I informed Constable Duke that Mr. Lespar declined to sign the statement. I entered the room and inquired from Sergeant Singh, Constable Duke, and Officer Narvendra Prasad whether Mr. Lespar was under arrest. I indicated to them that Mr. Lespar was desirous of leaving the premises of SOKU and returning to work. Superintendent Ramana then entered the room that I was in, and he instructed Officer Narvendra Prasad to arrest me. Clark further stated that she was instructed to follow Prasad into a room in the upper flat of SOKU headquarters. She was placed to sit on a chair in the middle of the room, after which Ramana entered to tell her that she was under arrest for obstruction and left. While in the room, she was in communication with Ali Kak via our cellular phone, after which it was forcibly taken away by Prasad. At the time, she attempted to leave the room but was prevented from doing so by 2 male officers who executed our arrest. A female rank that I had met at the gate when I entered the compound, Lance Corporal Alder, entered the room and sat in front of the desk by the door. I was wearing a Samsung smartwatch that allowed me to make and receive a call. I observed on my watch that I was receiving a call from my attorney, Mr. Hughes. As I answered the call, I informed Mr. Hughes that I had been arrested by SOKU and that I was upstairs. Officer Alder then demanded that I hand over my watch, and she attempted to take my watch from me. Clark had said that that she attempted to exit the room again, but was blocked by Sergeant Singh. She also requested the presence of her lawyer, but no mind was paid to her. Subsequently, attorney Alikak, Lamy, and Archibald entered the room, and Lamy requested Clark's phone from the officers, who ignored him. Shortly after, Mr. Hughes attempted to enter, but was prevented. Singh Lamy later left the room so that Hughes could have access to his client. Mr. Hughes entered the room and inquired from the officers in the room about the charge and the particulars. Constable Duke indicated that he had to go and get instructions from his superiors. A few officers left the room and returned. One of the officers indicated that I was arrested for attempting to pervert the course of justice. Mr. Hughes inquired from the rank what the particulars were, and the rank stated Mr. Hughes would have to call his superior, Mr. Karimbash, for that. Mr. Hughes attempted to call Mr. Karimbash on his cellular phone, but was told that Mr. Karimbash was busy at the time. Constable Prasad then entered the room and placed the phone on my lap. After a few minutes, I was told that I was free to go by one of the officers. And, you know, we had the lawyers came out and they demonstrated, and this article is saying here that the move to arrest Clark had sparked widespread condemnation from the local bar association and regional and international bar associations as well. And the last part here says, the Director of Public Prosecutions had recommended that no criminal charge be brought against Suku officers over their detention of Clark, and private criminal charges against them were also thrown out. So there's the background, there's what happened. So Ms. Clark moved to the court through her lawyer, Mr. Nigel Hughes, and they filed a lawsuit in the sum of $300 million. The Chief Justice heard the matter, and a few months ago made a lot of pronouncements saying that the police acted unconstitutionally, they violated the rights of the lawyer and all of that, and she had reserved the monetary damages to a later date. Well, we now learned that the Chief Justice issued the order, and the Chief Justice awarded the attorney 700,000 Guyana dollars for the wrongful arrest. You know, the first comment is that seems to be part of the problem. For such an egregious act, 700,000 Guyana dollars, which is like about 3,500 US dollars. So it's a slap on the wrist in terms of the award, but the Chief Justice also made some other orders. She said, and let me read what the Chief Justice said here. I don't want to misquote anyone. She said, within 7 days of this order, the Guyana Police Force must issue a public commitment to include in its training curriculum for all officers and ranks specific training on Articles 32, 39.2, and 139 of the Constitution of Guyana, the Human Rights Convention enshrined in the Constitution pursuant to Article 154A, and the United Nations publication, Basic Principles on the Role of Lawyers, pursuant to Article 39. And then the thing goes on to say, and I'm telling you what the articles, what the conventions are. The order of the Chief Justice, Madam Justice George, dated 17th of October. The conventions included in Article 154 are the conventions on the rights of the child, the conventions on the elimination of all forms of discrimination against women, convention on the elimination of all forms of racial discrimination, conventions against torture and other inhuman and degrading treatment or punishment, covenant on economic, social, and cultural rights, covenant on civil and political rights, Inter-America Convention on Prevention, Punishments, and Eradication of Violence Against Women. So the Chief Justice has ordered that the police force, the whole police force, all officers and ranks, the police have to make a commitment to ensuring that this is taught to all officers and ranks. Oh, what a slap. And the ranks or the persons directly involved had to issue an apology, and they did so. This is a letter of apology. I don't know if you can read it, but this is signed by Superintendent Romana and Assistant Commissioner Karimbash, addressed to Mr. Tamika Clark as ordered by the Chief Justice. They apologized, and they said that basically that it was, well, they say it was a mistake. Because what they're saying there is that A part of it says, upon mature reflection and upon legal advice received, we recognize that there was a violation of both counsel's right to advise our client to remain silent and to engage with our client in private, though though in the sight of investigators, and the consequential right of the client to receive the benefit of such advice. Then I say this error in judgment is only regrettable. That is what the two officers said. Well, let me bring in Mr. Conway to make his comment, and then we have something more to talk about it. CC, I'm sure you would have seen it. What are your comments on this?
First thing, I'm happy that the attorney took the steps in terms of challenging going before the court, led by Mr. Nigel Hughes, because the police were completely wrong. A complete breach of our constitutional rights, both she and her client. And the thing is that she asked for a public thing that the police must do training for all the police officers and other ranks. That is interesting because I don't know how they were able to monitor that, Paul, because police don't believe in sustainability. I don't think that word is in their vocabulary. You'll see a big thing, a big splash, the training commence, but then I doubt whether they were able to touch right down to the constables and all the officers. They make a good start. Yeah, and then after then it finished. So the Chief Justice has to ensure that our order is carried out to the hilt. And I know no bluffing as the police normally do. But then the police let me read the police general powers of arrest. And it's in section 16.1 of the Police Act, chapter 1601. Here's what it said. And this is the time of powers to arrest without warrant. It shall be lawful for any member of the force to arrest without warrant. A. Any person who commits, in his view, an offense punishable either upon indictment or upon summary conviction. Or B. Any person whom any other person charges with having committed a felony or misdemeanor. Or C. Any person whom any other person suspects of having committed a felony or misdemeanor. Or 2. Charges with having committed an offense punishable on summary conviction, if such person is willing to accompany a member of the force affecting the arrest to the police station and to enter into a recognizance to prosecute such charge. Or D. Any person such member of the force finds disturbing the public peace. Or E. Any person whom he has good cause to suspect of having committed or being about to commit any felony, misdemeanor, or breach of the peace. Or F. Any person he finds between the hours of 8 o'clock in the evening and 5 o'clock in the morning, lying or loitering in a highway, yard, or other place, and not able to give any satisfactory account of himself. And let me just summarize it. A talks about any person commits in his view offense either summary or in that one. B. Any person where a person charges. C. Any person where a person suspects or charges with having committed an offense, provided that person is willing to accompany a member of the force to the station and to enter a recognizance to prosecute. And then we have any person who the police find disturbing the public peace, and any person who has good cause of suspect of having committed an offense, and any person he finds between 8 in the evening and 5 in the morning, lying, loitering in any highway, yard, or place, and cannot give a reasonable account of himself. So there is where the powers lie to arrest with the warrant. And the police must read the police act. It's there. And this police act is easily available. You can purchase at the Parliament building. It's available, and I go there regularly, and and mind my words, and I purchase my law books. I don't otherwise up to, and I purchase my law books, and the police should go there and purchase the law books and they read them. They're reading a lot of things on WhatsApp. They're and all other things there, but they're not reading the law. So the powers to make arrests without warrant lies in section 16.1 of the Police Act, chapter 16, colon 01. So we look forward to see whether they will conduct the training and what will develop after them.
Yeah, well, let me just say, because I hope they do the training, but the order, the order, if you see what the order is saying, the order basically is saying that within 7 days of this order, let me read it here. Within 7 days of this order, the Guyana Police Force must issue a public commitment to include in its training curriculum for all officers and ranks, specific training on Articles 39.2 and 139 of the Constitution, and the ones that I read. So it is a commitment to do the training. So who monitors to ensure that the training is in fact done? Because all this is saying, as far as I can understand and interpret, because within 7 days, they have to give a public commitment that this training will be done. Yeah, they're going to give the commitment. Somebody going to write a public thing and say, yeah, this training is going to be done. What happens thereafter? Who is going to monitor to ensure that the training is in fact done? And the Chief Justice was specific to all officers and ranks. Now, let me tell you this. The system as it is, that is so broken, I believe right away you're going to have issues. First of all, who is going to do the training? Who will be the one qualified enough to lecture to trainees, to all the officers, all officers? And let me understand this clearly, The Chief Justice say all officers and ranks of the force, which means from the commissioner right down to the last joint constable. That is how this should be interpreted. All officers and ranks to undergo this training. First, to give the commitment. I have no doubt that that commitment will be given, but then the actual implementation of the training, I have my reservations as to how that will go. CC, let me bring you back in for you to see. How do you see this actual implementation going, my brother?
They will have a lot of it. For me, it's going to be a logistical nightmare for them. And who is going to monitor it? And who is going to ensure that this training was properly done? I don't know who will get to do it. But you can get a bluff thing. Yes, we did training. Yes, we did training. Yes, we did training. And but when you go down to the nitty gritty, I don't think it's going to happen.
Well, the important thing here is to make sure that the ranks, even outside the training, I would expect them to read this order and interpret it for themselves and understand the limitations of their powers. That will be the important thing. Whether they go through the formal training or not, as you suggest, they should get this order. It's going to be available publicly. It's in the newspapers. It's going to be there. They could get the order, read it. I would expect that even outside of the training institution, that officers are in charge of divisions, so officers in charge of subdivisions, officers in charge of stations will make sure that they have instruction classes to instruct and to teach their ranks exactly what this order means. That is what I would expect to happen. So even outside of the formal arrangement, where at the central level you have this training going on, officers should take the initiative in the divisions and make sure that this is done. But let me say this. The old story that the $700,000, because it's $700,000, they have to pay $250,000 as cost. And the Chief Justice did say too that if this thing is not implemented in the prescribed time, a further $300,000 and all of that. But who will pay? And perhaps that is part of the problem. It's not the Branks, Romana, and Duke, and Singh, and Passad. They are not going to be paying anything. It's taxpayers. It's us taxpayers will have to pay that. And what aggravates me and this whole situation is that no action will be taken against these ranks. None. None has been taken. And now that this order is issued, no disciplinary or any other action will be taken against the rank. As a matter of fact, let me say this. Some of the same ranks in October 2021, some of the same ranks. And let me tell you the incident. You remember on October the 15th, I attended the Georgetown Magistrate Court in answer to a summons that was applied for by Romana, the same Romana. And when I turned up in the court compound, Mr. Conway was there, he witnessed the incident. The Brahmana is arresting me for the same offense that he summoned me to attend court for in the court compound.